Morning, welcome to our Blitz webinar. This is the first time we've used the word Blitz, and there's a reason for that, because you've been given less than 48 hours notice to attend this important webinar. We released an article on what the Constitutional Court has done regarding retrenchment law, and we decided to have this webinar within 48 hours later for the following reasons. A number of our clients are undergoing retrenchments at the moment. Our country is, according to some economists, having where a number of our entities are experiencing economic challenges, and retrenchments seem to be the manner in which to address the economic challenges. We anticipate that retrenchments are going to take center stage during the course of this year. This judgment by the Constitutional Court and the judgment regarding the interplay between the retrenchment law and competition law, which Nadeem will mention briefly, materially impacts on your current experience. This is a Blitz webinar, so that means we're here to provide you with highlights within 30 to 40 minutes. We are going to be releasing, as always, a thought leadership guide so that you are able to empower yourself as you go through this experience. We will also be releasing an infographic which will illustrate what is the impact of this judgment on what you are currently doing. While this is a Blitz webinar, please feel free to contact your relationship partner at our firm so that we could have a coffee chat with you as to the impact on your particular environment. As you would have known of our firm, we quick off the mark on a number of things in order to bring you the latest information. So we have an esteemed panel. I'm just here to take up space in a couple of minutes. Nadeem is a director in our department, and he is the powerhouse behind this, ensuring that all of this happens. He's a doctor by profession and a lawyer part-time, but he's going to be facilitating this. And then we have our fellow directors, Jean, Asma, and Yvonne, who are going to engage with you directly. Nadeem will be facilitating this. I hope that this information coming off hot of the heels of the judgment assists you as you embark on your processes, whether you intend initiating them or you're in the midst of them. Retrenchment law, by this judgment and the Constitutional Court judgment, has been turned on its head. While the court, it impacts on what you're going through, the court has provided clarity as to what you need to expect when you are making provisions from a financial liability perspective. This is an important judgment that you need to take into account. My final point is, usually what used to happen on a large-scale retrenchment, organizations from a risk perspective used to say, well, if I lose in 2 years' time, my exposure is limited to substantive fairness, and this is the value of it. As Nadeem and the colleagues are going to speak to you, your provision now is going to have to take into account procedural unfairness within a large-scale retrenchment. You want to get out of this this particular judgment, the easiest way is reach an agreement. Finally, we're going to touch on 4 topics. Briefly, the interplay between the Constitutional Court judgment relating to competition law and retrenchment. In relation to this judgment, it deals with the issue of selection criteria, 2, process in a large-scale retrenchment. And for me in particular, this is one of the few judgments where costs were awarded in an employment law matter in the Constitutional Court. The question that Asma is going to touch on is, can I now, based on this judgment, ask for cost in employment law matters at the Labour Court, where the court used to always say, we don't award costs at the general level. Colleagues, I hope you enjoy this. Karushka, my colleague and the head of our business development, will make the slides available. This is not a Steve Jobs presentation. We're not going to have slides. We are having slides because this judgment is so technical. This particular webinar will be sent to you by email, and it's going to be posted on social media. Thank you. We hope you enjoyed, and look out for our thought leadership guideline. Over to Nadeem Mohammed, my fellow director. Thank you, Nadeem.
Thank you, Adil. So a second welcome to everyone. Thank you for being with us. As Adil has indicated, this is a significant judgment of the Constitutional Court that has provided confirmation and clarity on the issue of selection criteria and retrenchment, the correct procedure to follow in order to challenge unfair procedural issues in large-scale retrenchments, and the general rule on costs in labour matters. But before I proceed to our esteemed panelists, I think a brief context of the facts of the judgment is relevant before we get into the details of the principles and the legislation. So in this case, we have an employer who embarked on a Section 189A retrenchment process, so a large-scale retrenchment process. The employees found the process to be both procedurally and substantively unfair. In response to that, they did 2 things. The first thing they did is they initiated an action process to deal with the substantive fairness issues. In addition to that, and after that, they also initiated a Section 189A13 application in the Labour Court to deal with the procedural issues. These 2 were consolidated later by the Labour Court. By the time we get to the Constitutional Court, the employer is appealing the reinstatement order in favour of certain employees whose substantive fairness claim was successful in the Labour Appeal Court, and the employees whose unfair procedure claim was unsuccessful are appealing the order of the Labour Appeal Court, which indicated that the Labour Court had no jurisdiction to entertain an application in relation to unfair procedure in a large-scale retrenchment. So we'll be discussing these relevant elements regarding both the procedural and substantive dimensions of this matter. So to start us off, Jean, can you contextualize Section 189A of the LRA for us, please?
Thanks, Nadeem, and good morning, everyone. So yes, this judgment is primarily concerned with Section 189, capital A of the Labour Relations Act, and that regulates large-scale, what we refer to as large-scale retrenchments, but it's really retrenchments that deal with employers who employ more than 50 employees. And within this section, and Asma and Yvonne are going to break it down even further for us in terms of what the judgment highlighted. But within the section, it makes provision for things such as facilitation by the CCMA in large-scale retrenchments, and also puts in place timelines to be applied that are applicable to the consultation period. Whereas Section 189 simply deals with employers who employ less than 50 employees and doesn't make provision for things such as facilitation. So that is a feature of this judgment which Asma and Yvonne will unpack. But one of the things which, as Nadeem has mentioned, the appeal that came before the Constitutional Court related to a finding of substantive fairness. And something that then the Constitutional Court then addressed and dealt with was the issue of selection criteria. So just very briefly, As part of the retrenchment process, there was a restructure that took place within Regenesis, and this we gleaned from the Constitutional Court judgment. And Regenesis presented this final new structure to the employees, and employees then had to undergo a competitive process whereby they applied for positions in terms of this new structure. The employees who were ultimately not placed were then retrenched. Throughout the Labour Court proceedings, it's clear that the case that was ran by Regenesis and the employees as well in this instance was that the selection criteria that had been utilized for the retrenchment was that of skills, knowledge, and behavior. And so that had been, it seemed there had been no dispute that that was in fact the selection criteria. When Regenesis gets before the Labour Appeal Court, they then indicate that in fact the selection criteria was not skills, behavior, and knowledge, and they indicated that that only applied to the competitive process that was followed for the filling of the vacant positions, and it was not the selection criteria for dismissal. The LAC rejected this. It came again before the Constitutional Court, and Regenesis sought to rely on the judgment of SA South African Breweries versus Lowe, which is an LAC case. Very briefly, the principles that we get from the SAB case, which is really what's important for the purposes of this case, is that in a restructuring exercise, where an employee's position becomes redundant because there's a new structure and their position no longer exists, they're not automatically dismissed, they're just simply displaced from the structure. And it's only after all the opportunities to relocate them within the new structure are exhausted, may they then be fairly dismissed. But where that displaced employee takes place in a competitive process for a new position and fails, this does not automatically convert the assessment criteria that was used for the competitive process into the selection criteria for dismissal. And so there's a distinction that has to be drawn between this assessment criteria that was utilized during the competitive process to try and fill the vacant positions versus the selection criteria for dismissal. And so the Regenesis sought to rely on the Lowe case to say that, well, yes, they likewise had that distinction where the selection criteria was distinct from the selection criteria for the assessment process was distinct from the selection criteria for dismissal. And what the Constitutional Court said was that, firstly, two issues. The first thing is that in the Labour Court trial that was ran, the case that was run by the parties was that the selection criteria was skill, behavior, and experience. The Con Court said, there's nothing wrong with having that inherently as selection criteria. And there's nothing in the Lowe judgment that indicates that that there's something wrong with having that a selection criteria in general, and that the reliance on the Lowe case was therefore incorrect. But another problem that the Constitutional Court raised in relation to the selection criteria was that if they were in fact making this assertion that the skills, experience, behavior was not the selection criteria for retrenchment, then in fact it appeared that there was no selection criteria. And the Con Court emphasized that that's even more unfair than having these criteria as the selection criteria. So the importance that we get in relation to selection criteria from the Lowe judgment, but more especially from this judgment, is that where employees are displaced as a result of a restructuring process and they are ultimately then unsuccessful in the competitive process, it's still necessary to have selection criteria for dismissal. And if you cannot agree to those selection criteria, then the criteria must be fair and objective. And that's something I think that we should know as we go through these processes, but sometimes we lose sight of. And so this is a very good reminder from the Constitutional Court that notwithstanding the competitive process, you must still have selective criteria, and that selection criteria must be fair and objective.
So, Jean, I mean, what the court seems to be saying is that an employer cannot use the assessment in a competitive process in a new structure during a retrenchment to mask the either an unfair process or rather the lack of fair selection criteria, and that the selection criteria is a standalone requirement in order to ensure that the times are actually fair. Would that be a correct interpretation of what the court is saying?
Absolutely. So the court is emphasizing that there is that distinction that we know that comes from the law case, that you have your competitive process where people apply for vacancies, and that is not inherently unfair. The LAC in law confirmed that, and this court does not take issue with that in this Regenesis matter. But the fact remains that that doesn't excuse an employer or doesn't remove the requirements to have selection criteria, and those selection criteria must be fair and objective. And so when we go through these processes, we must be mindful of that. And of course, even worse, if you don't have selection criteria, of course, that's going to make the substantive fairness, terribly unfair.
And obviously, first prize would be to have the parties agree on what that selection criteria is to avoid any future disputes. And if there is no agreement, then the employer needs to really ensure that the selection criteria is clear and is fair and objective.
Exactly.
Thank you,
Thanks,
Jean.
Nadine. If maybe I just can jump in.
Sure.
So if you look at the section 1893 notice, right, it's like a template. Where when you have to consult the things that are mandatory that you actually need to consult on. So there is really little room that you will not even touch on selection criteria if you follow that notice, because it is actually quite clear. I think as someone mentioned, that can actually be a cheat code, right? That's just the requirement. Go through it and consult on it, and if you aren't able to agree, it's not about agreement, it's about trying to reach a consensus. And if you are, I think as an employer, are convinced that the criteria that you've put before the consulting parties is fair and objective, then you will be able to implement in terms of that. Thanks, Lady.
Thanks, Yvonne. Thanks for that. That's an important clarification and consideration to take into account. But Yvonne, I wanted to ask you in respect of section 189A13. The court clarifies when this is an appropriate process to utilize. So can you please provide us with some information or comment on this process as the correct process through which to challenge or raise issues regarding procedural irregularities or unfairness?
Thanks, Nadine. So the Concord, or maybe before I start with what the Concord is saying. So section 189.13 provides for a process in the Labour Code with the consulting parties or employees claim that their process or their retrenchment or restructuring process was procedurally unfair. And this is in the context of a light scale retrenchment in terms of section 189A. It also makes provision, you'll see in the slide there, of the remedies that are available to people who are invoking these provisions or are bringing this application. And this will be dealt with later by ASMA. So the Constitutional Court, what it does in this application, in this judgment, is that it confirms that Section 189A13 application is still the correct process to challenge procedural fairness in a large-scale retrenchment process. And this is also because an employee who wants to, or employees that want to challenge substantive fairness or substantive fairness of their process can bring a separate action proceedings. What then used to happen, people would then plead the assertions that, strictly speaking, are supposed to be in section 189.13. So what the court is confirming here is that if there is a challenge for on process, the fairness of the process, this section 189A13 application is the correct process.
So in short, Yvonne, what the court is basically saying is that if there's a challenge to the procedural fairness of a large-scale retrenchment, you are, as an employee or a party, precluded from going by way of action or pleading pleading a case of procedural unfairness in a substantive unfairness action matter. And so the appropriate action that you need to take is exclusively through Section 189A13.
Absolutely. So inadvertently, you then have a party having two matters, but Asma will also tell us about what happens with that. So you cannot use the action proceedings to exercise your right in terms of procedural unfairness.
Thanks, Yvonne. Asma, so to come to the meat of 189A13 and the interpretation of it, Justice Zondo provides in extreme detail an interpretive framework for Section 189A13 by making comment on prior judgments of the Labour Court, the Labour Appeal Court, and the Constitutional Court. And in a significant way, the interpretation advanced by the Constitutional Court is what makes this judgment notable. So can you take us through the court's understanding of the content and application of Section 189A13?
Okay, so firstly, what Justice Zondo says at the outset is the question, according to him, in the cross appeal, and you explained what that was, and that's the challenge to the procedural unfairness, is that given the provisions of Section 189A18, which in the Labour Court specifically says that procedural unfairness should not be, and it's mentioned in Section 189A, will not be determined by the Labour Court. The Labour Court has jurisdiction to determine disputes about procedural unfairness of dismissals of employees for operational requirements, or whether they're precluded from doing so for operational requirements in general, or the procedural fairness of a dismissal for operational requirements to which Section 189A applies, which Jean and Yvonne have both explained what that means, and that's more than 50 employees, and then a specific amount of employees that you're going to be affected by the retrenchment. So he at the outset says this is what the question is that relates to the procedural fairness question is, and he stated that the Labour Appeal Court in this particular matter held that the Labour Court didn't have jurisdiction to adjudicate the procedural fairness of a dismissal. And he says that this decision by the Labour Appeal Court, and they don't really offer much after they say that, they just say that, and they say it's based on the conclusion of the Constitutional Court judgment in Steenkamp 2. Now, as you've said already, what Justice Zondo does say is that there are a number of cases in the Labour Appeal Court and in the Constitutional Court and in the Labour Court which contain statements which either suggest that the Labour Court no longer has jurisdiction to adjudicate disputes about procedural fairness of dismissals for operational requirements, including those that are brought in terms of subsection 13. And he now wants to provide clarity on that, because he ultimately says that this is incorrect. That in terms of that the Labour Court does have jurisdiction to hear this, and they have jurisdiction to hear it in terms of subsection 13, which you've already displayed on the screen, and you'll see those are particular remedies. Now, what he says is that and I don't know if you want to, what I'm going to do is move on to the next point, if you don't mind, or if you want to just go into that. Yeah,
yeah, the Constitutional Court provides a hierarchy, right? So Zondo seems to suggest that 189A13 is made up of a set of primary remedies.
Yes.
And then 189AD is a secondary remedy, but in some ways also an independent one. So maybe take us through how the court reasons through that.
Okay, so what Justice Zondo does in this 124-page judgment is he mentions all the specific cases that that he says he refers to, which some people have interpreted to completely oust the jurisdiction. And he mentions in each of them how that's not necessarily the case for each of them. Some say different things, some say others. But what he says ultimately is that his position or his view is that subsection 13 has two purposes, not one purpose. Subsection 13 has a primary purpose and it has a secondary purpose. The primary purpose is to enable the Labour Court to make an order to compel the employer to comply with a fair procedure before employees are dismissed, finally for operational requirements. Okay, so the orders of the Labour Court are capable of achieving the primary purpose of subsection 13. Are the orders contemplated in, and if you go back to the previous slide, which you've already showed, it's A to C, right? So that would be all the remedies except for the last one, which is compensation, right? An order for the award of compensation contemplated in D is not capable of achieving the primary purpose of subsection 13, but serves a different purpose, namely what he calls the secondary purpose. And the secondary purpose holds an employer who has now already dismissed employees finally for operational requirements without compliance with the fair procedure accountable, and ensures that the employees whose rights have been violated are granted the appropriate relief without insisting on compliance with a fair procedure. And he goes on to say that the secondary purpose relates to an order for this compensation payment. And it's correct to say that an order contemplated in A to C can't be granted when the consultation process can no longer be put back on track, because putting the consultation process back on track is the primary purpose of orders contemplated in A to C. An order for the payment in D can't be refused on the basis that at the time the consultation process cannot be put back on track, because that's not the purpose served by an order for payment of compensation. The purpose served by an order is therefore what he calls the secondary purpose. So he separates A, B, and C as the primary remedy, and he says that D is the secondary remedy, but he says that they are essentially standalone remedies. He says that would it be appropriate, or when would it be appropriate for the Labour Court to grant an order contemplated in paragraph D? And he says specifically in the judgment that each case has to be decided on its own merits, and changes in the operations of the employer may render it inappropriate for them to grant an order under A, B, or C. If employees whose retrenchment is contemplated, say, for example, resign during the consultation process, then an order contemplated in A, as you've seen, wouldn't be appropriate. So he says that there are all of these remedies. Yes, as a primary remedy, yes, as a secondary remedy, but he's ultimately saying that they can be standalone remedies. And he mentions that quite a few times in the judgment. And yeah.
So yeah, he tries to bring it home on a few occasions. So
yeah,
I mean, so what the court is effectively saying, Asma, from what I'm hearing you saying, is that the first, the priority is to ensure a fair process. Yes. And you would get that by trying to put the fair process back on track, and that is done through reinstatement. Yes. Right? So it's either through while you are conducting a 189A process, so there wouldn't be reinstatement, but there would be a particular orders on what constitutes a fair process. Yes. Or even very soon after a person may have been dismissed for operational requirements and there's some procedural irregularities, the court can order reinstatement. And in fact, the Constitutional Court says that even up to 3 or 4 months after a person may have been dismissed, reinstatement may still be appropriate. Yes. But there may be instances where that is not an appropriate remedy. And it gives, so this case is an example where the procedural unfairness claim is only adjudicated 2 years or 3 years down the line. Okay. Or, for example, another example that's provided by the Constitutional Court is where the employees are employed, or the employer is a natural person. Yes. And shortly after the conclusion of the retrenchment process, the natural person dies or passes away, and then effectively it's impossible to order reinstatement in that circumstance, and that's when D as a standalone remedy would actually be applicable.
Yeah, like if the death happens before the employees launch their 189A13 application, then obviously then reinstatement wouldn't be adequate or appropriate, and then you would. So in this particular case, they didn't just claim D, which also Rogers in her minority states, in the minority states, that they didn't actually raise. It's not the question of standalone never really came up, but because they referred a C remedy, and in the alternative referred a D remedy. But what Justice Zondo is saying is that it can be done standalone. Yeah.
So I think one of the consequences then of this judgment is that there will be probably more claims regarding procedural unfairness that may come long after the process has been concluded by the employer. And can also come in circumstances where people are out of the 30-day time period and have obtained condemnation, as was the case in this matter. And so employers need to, as Adil indicated in his introduction, probably make provision or budget for potential claims that may arise at least sometime after a retrenchment has been concluded in a 189A process. And that brings me to the point that Adil mentioned in respect of an earlier Constitutional Court judgment, which dealt with a merger and a retrenchment. And in terms of that judgment, the court confirmed that when you have merger approval conditions that prohibit retrenchments as a result of the merger, as provided there's no causal link between the merger and the retrenchment, retrenchments are fine. But what the merged employer needs to take into account that there may still be challenges in respect of procedural unfairness down the line, which they may need to also make provision for financially. And so this leads us to an increased exposure to costs potentially. Would that be a fair assessment?
Yeah, definitely. So it would be it would be a cost consideration, but you would need to see whether, if your procedure was unfair, for example, and was found to be unfair, they applied for condemnation as they did in this case. The matter was heard a few years down the line, even after, say, any other action was launched. Then you are at risk for compensation under 189A13D alone, as a standalone claim that they would have made. So it does, I think that's the part of this judgment that is a little bit scary, is that obviously when it comes to considerations of condemnation, the general principles will need to be considered. And the court will consider it, as Prinsloo J did in the Labour Court judgment of this matter. But would courts be more inclined, when it's a standalone remedy, to grant condemnation, especially in instances that we might have mentioned? You mentioned one, which is the death of a natural person, but there's a 197 where 197 doesn't apply and a business is sold. That could be another one. And that would be a standalone remedy, because that business would obviously not exist anymore. So it is a bit scary for employers to think about, but it's something that they need to think about, because these applications can be made together with condemnation later down the line.
Definitely. My last question, Asma, for you is on consolidation. So in this matter, we found that the Labour Court consolidated the 189A13 application together with the action matter relating to substantive fairness. Do you have any comments on that, and how possibly more frequent this type of consolidation may take place at the Labour Court in future, and what that means?
So that's precisely what happened. So as you explained, what they did was they referred a substantive fairness action, and then thereafter, I think shortly thereafter, in September, which is about 2 months after the dismissal, they referred a Section 189A13 application. And what Gush J did in this particular matter, because I think he was the judge that was doing case management before passing it over to Prince Lur J, was he consolidated these two matters. And what the LAC found was that, and they specifically said that, which confused Justice Zondo to a specific extent, was that it almost seemed as though he said the consolidation in itself was almost the issue, and they didn't really. He says it's not very clear from the judgment of the LAC what role the consolidation of the substantive fairness matter and the procedural fairness matter played in determining whether the Labour Court had jurisdiction to deal with the matter. Because he says, of course, the consolidation of any matter with another matter can't affect the jurisdiction of a court to deal with a particular matter. So if a Labour Court has jurisdiction in respect of a matter before its consolidation with another matter, then it would still have jurisdiction in respect of the matter, even after these two matters have been consolidated with another. So consolidation can't confer upon a court jurisdiction which a court otherwise never had. So he criticized a little bit, or he says, he criticized a little bit the LAC's lack of reasoning. But what can ultimately happen is that these two matters can be consolidated. They'll be referred at different times. Zondo saying that's perfectly fine to consolidate these matters because you have jurisdiction to hear both of them. Yeah. One will come with condemnation. And what this might lead to is judges, when they have potential disputes of fact, which is there on the slide, on particular matters. Now remember, in this matter, the procedural fairness is quite overt. There might be potential disputes of fact, and what that might lead a judge to do is sort of decide that maybe consolidating these matters will be better. And what that eventually ends up doing, as in this case, is you might claim your remedies from A to C in your initial application. The consolidation of the matter might again just delay the hearing of this matter and end up being heard down the line, and then it would just fall under compensation claim under D, which then can happen and which did happen in this particular case. So we may be seeing that happen a little bit more.
So in short, these matters can be consolidated. They do not deprive the Labour Court from jurisdiction to hear them in a consolidated form, and there may be an increase in the remedy of compensation under Section 189A13D, because if a Labour Court potentially hears matters down the line in relation to unfair process, D would become the more appropriate remedy.
Exactly, even though you claim C.
As time passes, because reinstatement becomes less and less appropriate or probable. Right. Yvonne, I'm going to come to you in respect of costs. So the general rule in litigation is that costs follow the result, which means that the losing side will be paying the bill when it eventually arrives. In short, I know it's a bit more complicated than that, but that's generally what it means. But like most things, there's always an exception to the general rule. The exception here is in labor disputes. And the Constitutional Court emphasized that in labor matters, courts have discretion to consider fairness and the principle of law when making cost orders, taking into account the unequal power relationship between employees and employers. So can you take us through the cost order in this judgment, where the cost order of the Labour Court in favor of the employees and against the employer was reinstated by the Constitutional Court, and what this means for employers?
Thanks, Nadine. So when I saw this cost order, I just saw a whip, and because of the norm that the Constitutional Court acknowledges. So the Chief Justice says that the norm in the Labour Court, in labour matters, is that no costs are awarded, and we've seen even with urgent applications when There's been wildcat strikes. The courts are just reluctant to award cost. And so with that acknowledgement, he also goes on to say that, but in this particular case, the Labour Court did award a cost order against did award the cost order against the employer, which is Regenesis in this case. And when the matter went to the Labour Appeal Court, the Labour Appeal Court then set aside the cost order, and when it substituted the Labour Court order, and when the Chief Justice dealt with this issue in the Crown Court, he set aside the Labour Appeal Court order in relation to a cost order, and so in essence he reinstates the cost order. And one of the aspects that he raises, he says that the appellant with Regenesis did not actually raise this as part of the appeal. So the Labour Appeal Court erred in setting it aside. He also points out that when you don't plead a claim, if you don't make an allegation of something that you want to be set aside, the court cannot mere to do that. There are exceptional circumstances, and he also deals with that. But he says that in this particular case, that was not warranted, or those exceptional instances were not prevalent in this. And if you look at what is quoted there, he proceeds to say that while he acknowledges that the norm in labour matters cost orders aren't awarded, he says, but in this particular matter, in this particular case, the cost order against Regenesis is warranted. And he mentions specifically about the manner in which Regenesis handled the restructuring and the retrenchment process, and how it conducted the consultation process. And he specifically says that really warrants or justifies the cost order. And when one looks at the judgment with scrutiny, you would see that a couple of things that just did not go right with this retrenchment and restructuring process. And one of them is the consultation process. I mean, I drew my own timeline in relation to how long did this large-scale restructuring process started. So on the 17th of June, there's a meeting, I call it meeting one, and the very next day, it's a consultation process. The employees are being given the proposed structure, and the following week, which is another Wednesday, they're already been given the termination letters, and then they're going to the notice period is in July. So as you can just see that the timelines are truncated, and it just goes against the spirit of large scale restructuring. And then the next aspect that one looks at is what Jean spoke about, which is the selection criteria. About the manner in which they dealt with the criteria of selecting people, to place people into roles. And the Chief Justice also mentions that there are people who were displaced in the roles that they actually occupied before this restructuring process was undertaken. And the other aspect that is pointed out is there was a facilitation request that was made after the first consultation, when the employees had been taken through the rationale and the new structure, and the judgment, it's clear that it wasn't even, well, the judge says, the Chief Justice says, it doesn't even look like it was acknowledged, doesn't even look like it was actioned. There seemed not to be a response. So in essence, there was no facilitation, but more than that, the employees were not addressed. There was no response to that. And the other aspect is about the misrepresentation of what the rationale for this restructuring. So on the one hand, there is an economic reason that is informing this restructure, and the basis why employees may be impacted. And on the other hand, it talks about wanting to create efficiencies. So the one talks about when evidence was being led, the employer's witness then makes mention of the fact that they had to change the reasons for this, so that they can mitigate their risk with third parties and in the markets, and that's the court found that. And then the last aspect that that stood out is how they also handled other individual cases. There is an instance where one employee was started off as was approached and was put under performance, or was advised that her performance is not up to standard. And then there was the parties entered into a mutual separation a discussion, and when that did not that was not successful, then they were issued, the employee was issued with a Section 1893 notice. So all of those aspects, you can just see how the Chief Justice would get into this conclusion that the manner in which this process was handled was really or justifies the court order. So of significance for us and our clients and employees specifically is that we, notwithstanding what the norm is, so that is accepted as a norm in relation to cost orders, but we may start seeing or parties, let me put that way, parties pushing for cost orders or even punitive cost orders, and when that happens, we will start seeing courts placing restructuring processes and retrenchment processes under magnifying glasses. So it's going to be critical that when we embark on these processes, that we are diligent and we comply. We made mention about what you need to consult on the Section 189 notice, which is derived from, or is drafted from the Act, will give you guideline on what you need to consult on, and the recordals that you need to keep, so that you're able to justify, for instance, why you believe that the selection criteria was fair and objective. Thanks, Nick.
Thanks, Yvonne. So, I mean, in this case, I mean, there was a lot that was amiss or awry about the process, and I think what the court effectively says is that the unfairness was so evidently clear that it actually departs from the norm on costs in labour matters where no costs are awarded, and actually reinstates the Labour Court cost order here, saying that the employer acted in a patently or evidently unfair manner. And I think potentially what you're saying then is going forward, where there is evidence of a party or an employer acting in such a way, there may be more pressure, or there may be more direct claims for cost orders based on how this judgment went, on this Constitutional Court judgment is.
Absolutely. I mean, when people plead for cost orders and they mention, they will start nitpicking. So when you were supposed to consult with me after 3 days, you didn't. When And that just puts the whole process under scrutiny. So it's important that, that level of diligence and recording, and don't take things for granted, because this cost order is quite punitive. And we're not saying that it will always be that way, but it just shows that when the parties start pushing, the process will start being will be scrutinized. It will be under magnifying glass, and everything may be nitpicked for unprocedural fairness. Thanks, Nadine.
Thanks, Yvonne. Jean, at the end of the day, what should employees be aware of, and what action should be taken to mitigate any risks, just generally in terms of entrenchment, and also particularly in light of this judgment?
Thanks, Nadeem. I think firstly, and this is something that Asma and Yvonne have been trying to highlight to us, is that you must adhere to a fair procedure always. I know that that's almost it almost seems like we're stating the obvious, but I think that this judgment has really highlighted the risks that would be associated with not following a fair procedure, particularly given that we now have almost a standalone remedy of compensation that arises from unfair procedure, and it's not limited to the 30 days. So that's the first thing, is that you must follow a fair procedure, and also you might find yourself, at the receiving end of a nasty cost order, like in this instance. Secondly, is that it pays to utilize the CCMA facilitation process where possible and where possible. Of course, we know that Section 189 capital A makes provision for a facilitation process, and the employer is the one that can actually request a facilitation. In this case, it was raised by the employees that request was ignored or not even considered, it seems like. But the utilization of a CCMA facilitation process can, to a large extent, cut through some of these procedural missteps that occurred, because it would have been facilitated externally by someone who's trained, and maybe they would not have ended up in as bad shape as they did in this case. The other takeaway for consideration is that when the Chief Justice in his judgment was discussing why he believed reinstatement was justifiable, one of the things that he mentioned is that there was extensive delays in the matter coming to finality, and he indicated that those delays were not caused by the employees in this instance, and he uses that as one of the justifications for reinstatement. So in our prosecution of these matters, we must be diligent, we must prosecute them timelessly, because it might come back to bite employers, not just in how much you have to reinstate someone, the back pay, but also just that might be something that's held against you. And lastly, I think, is the awareness of the Section 189A 13 procedure. As Asma's highlighted, it's serving two purposes. The first being, primarily to get the process back on track. Where that's not appropriate, then compensation is going to come in, and they are going to be two separate processes. So we're going to be seeing an increase, I believe, in people making use of that process, even outside of the 30 days that's set out in that section.
No, definitely. And maybe the one thing I would add is that employees pay attention to implementing or applying agreed upon selection criteria, or if there isn't any agreement, at least fair and objective selection criteria. And that's irrespective of whether it's a 189 or 189 process.
Exactly.
Okay. Thank you. I think we've come up to our time. Thank you so much, Jean, Yvonne, and Asma, and thank you to our audience for joining us and affording us an opportunity to share the details and consequences of this important constitutional court judgment. We look forward to being with you again in the future. Thank you and bye.